Um, so I am Eileen Doherty, and I am the director of the Colorado Gerontological Society. And this afternoon, we're going to talk a little bit about advanced care planning. Specifically, we're going to look at the issue of guardianships. So guardianship is basically something that we do for an at-risk adult. An at-risk adult is basically anyone who is 70 years of age and older, or any person who is 18 years of age or older and is a person with a disability. Now, this is Colorado law. This is not necessarily true in other states. I believe that our law is similar to other states, but you may find variation depending on where you are actually working with someone. In terms of as we are working with at-risk adults, one of the things that we're always concerned about is, what does informed consent mean? And informed consent really is a very legal kind of definition. It means that the individual has a clear appreciation and understanding of the facts, the implications, and the consequences of the action. So when I do something, in order for me to give informed consent, it means that I have to know and understand what it is that I am doing. You have to have the ability to adequately have adequate reasoning skills, and you have to have the facts to be able to make this informed decision. If there are any kind of impairment to either reasoning or judgment, and this could be because of intellectual problems, it could be because of emotional problems, stress, PTSD, intellectual disabilities, mental disorders, intoxication, sleep deprivation, Alzheimer's, being in a coma, any reason like that can, in fact, cause a situation where you would not be able to give informed consent. So if things are kind of rolling around in your head and you're not sure what's going on, giving informed consent can be very, can be subject, if you will, or open to discussion. So before we do guardianship, many times we look at what are the opportunities or the options before we get to a guardianship. So we're going to spend a few minutes looking at some of those. So in terms of making financial decisions, one of the ways that we can do that with both the Veterans Administration as well as the Social Security Administration is that they have their own process for designating a representative payee. This is an individual who may or may not be related to the person needing support or needing help making financial decisions. It is at the discretion of the claims representative at Social Security to interview you and deem whether or not you are capable of functioning as the representative payee for this individual. Sometimes we will get orders specifically for a single purpose. So we might have an order that is specific only for handling the checkbook and money, but not handling anything else. We often use a durable power of attorney as the primary way in which we manage other people's money. Another way that we can manage people's money is by having a joint bank account. And so one or the other individuals can either sign independently or both people have to sign. Another way, which I use a lot, especially with some of our older adults who may have some memory impairment, is actually using electronic bill paying and or deposits. I'm not a big fan of that for some kinds of paying all bills, but things like paying the rent, the utilities, paying on the prescription drug bill, those really do help to simplify the need for people to remember to do them. In terms of healthcare decisions, again, as an alternative to guardianship, we might draw up a medical power of attorney. And a medical power of attorney then has the same powers, if you will, and ability to make decisions for the individual as their agent. And that is a much cheaper alternative, usually, to guardianship, because in a guardianship, we have to prove incapacity. Whereas on a power of attorney, the person has to give informed consent, and then we can make decisions doing or using that. Another alternative to guardianship is maybe using some type of crisis intervention. This might be things like mediation, counseling services, some types of community-based services, again, specifically to meet the person's needs where they are. In terms of when we're looking at community services and really looking at guardianship as a last resort, sometimes we can engage either care management or case management services. These are individuals who function in the community with the expressed intent of providing the kinds of services that we might need. So they may be charged with making sure that we have food to eat. They may be charged with cleaning the apartment, making sure our prescriptions get filled, taking us to the doctor, that kind of support. Some other community supports that we can use are bill paying services or money management. Again, these sometimes are part of a care or case management program, or they can be independent standalone services. Another form of way to manage property is by owning everything in joint tenancy. What happens in joint tenancy is that if we own a house, my half is exactly the same as my husband's half, and we cannot divide it. So whatever is his is mine, and whatever mine is his. Owning things in joint tenancy then allows either of us to take action on that property. If one of us dies, the other then takes over as the tenant in common, and we own the property, passes outside of the will, and allows me then to make whatever decisions I need. Similar with joint bank accounts allow both individuals, or if there's 3 or more signers, anybody who's a signer on the bank account, even if one person is no longer able to sign or they are deceased, then the other person who is a signer or persons can go ahead and continue to manage that bank account. Sometimes we also will create a trust, and a trust is created for the specific purpose of usually avoiding probate and or preserving assets for an individual or for our heirs. Frequently, again, you would create a trust as an alternative to guardianship, where the trustee would then be charged with paying again for bills or providing for housing or whatever. So what is the difference of a power of attorney versus a guardianship? So a power of attorney, basically the person has to have capacity and they have to be able to give informed consent. On a guardianship, this is a court-appointed action, and oftentimes when there is a guardianship given, the individual does not have the capacity and they are no longer able to give informed consent. So, doing a power of attorney when you have the ability and you can make decisions for yourself, you can then choose who your agent will be to make decisions. In a power of attorney, you, the individual, are in control. You make your own decisions, whereas in a guardianship, the court is going to decide. And once the court deems a guardianship, then basically they supervise any decisions that are made about you for the rest of usually your life. In Colorado, for powers of attorney, we have both pre-printed forms, or you can have an attorney draw one up for you. In the financial power of attorney, that pre-printed form, it's not mandatory, but there is a template in the state statute. So most attorneys use either the pre-printed form or they use the form that is already in the statute. In the medical power of attorney, that there are pre-printed forms, but you may want to have an attorney draw it up if there are specific things that you want. On a guardianship, those forms, you do have to file all of the court documents and go through the process. The power of attorney is in force until the principal says, I no longer want you to be my agent. Oftentimes, especially at end of life, the principal no longer has the capacity to discharge an agent. So that goes on regardless of whether or not the individual is able to give informed consent or understands what's going on. The court in a guardianship will make the appointment of the guardian. Usually it's done 1 year at a time. And then the reappointment is based on the guardian filing a report with the court and that being approved by the court. And then there is an appointment made for the successive year. This report that is made to the court includes not only an accounting of the financial situation, but it also includes the care plan and includes how you plan to provide for the individual for whom you are guardian. Power of attorney can basically be done free if you use pre-printed forms. If you use an attorney, obviously there will be attorney's fees. And if you do a guardianship, although you can do them yourself, there always will be court filing fees, some attorney's fees if you use an attorney, and there may be physician fees. Sometimes we get asked, what is the difference of a guardianship versus a conservatorship? So a guardianship is basically the court appoints someone who is responsible for the person's health, safety, and welfare. What that means is that the guardian then is responsible for making all kinds of health care decisions, whether it's when you go to the doctor for surgery, whether you have a feeding tube, whether you are moved into a nursing home or a skilled rehab facility, whether or not they're going to approve you taking one kind of medication. All of those kinds of things are then the requirement of the guardian to make decisions. In addition to that, because it not only says health, but it also says safety and welfare, as a guardian, you are also responsible for making sure that the individual has appropriate and adequate housing, that they have transportation to get to and from wherever they need to go, whether it's medical appointments, the grocery store, church, or whatever. As a guardian, you're also responsible for making sure that they have clothing. Again, we operate on the presumption that if you are someone's guardian, they are unable to give informed consent, they're unable to understand or make decisions, and that becomes your responsibility. Now, sometimes people have a limited guardianship Or one of the other requirements, usually in the guardianship, is that you have to involve the ward, which is what a person who has a guardian is called. So you are supposed to, as the guardian, involve the ward as much as possible in decision making. So I, for example, am a guardian for an individual, and he is able to get himself to and from the grocery store and make a lot of his own decisions. So rather than my helping him to buy groceries, I actually just give him money, and then he gets himself to and from the grocery store and buys his own groceries. Similarly, he does his own cooking and his own laundry. In a guardianship, as I said a few minutes ago, you also have to have a plan of care, and that is approved by the court. On a conservatorship, this is a little bit different in the sense that the court will appoint someone to manage the individual's finances. So they will manage their income as well as their assets, their resources, their personal property, any real estate. A conservator has a fiduciary responsibility. Most fiduciaries, if you operate as a fiduciary, are bonded for the specific purpose of making sure that, again, any financial transactions that they are responsible for are done in good faith, and that there is no negligence involved. If you are a conservator and you need to report to the court, please keep all of the receipts and provide any kind of regular updates to the court. Now, if, for example, the individual does not have very much money, say they are on SSI, they have $800 or $900 a month in income, usually a conservator is not appointed in that situation, but the guardian is required to take over those duties for very small estates and when there is basically no property involved. So when you file for a guardianship, there is an initial screening that is going to be conducted by the court to determine if there are less intrusive alternatives. So a guardian ad litem, for example, might be appointed to visit with the individual who is being considered for a guardianship to determine whether or not they believe in that the person does in fact need protection. May also be a court visitor, so depending on the court who is appointed. If the individual who is needing a guardianship does not have their own attorney, the court will appoint one. You are the person who is filing for the guardianship. You have your own legal counsel, and then the person for whom you are filing for guardianship has their own attorney. So there are two attorneys involved. And again, in the United States, our court of law says that everybody has the right to legal representation. It is possible that the court could appoint either a temporary guardian or a conservator if there is an emergency. The courts don't look very favorably on emergency guardianships and conservatorships, especially for older adults who are like suffering from dementia or other diseases like that. They're more favorable if somebody is like a victim of abuse and then is also unable to make or give informed consent, then they're more likely to do temporary guardianships. What a temporary guardianship or conservatorship does is it basically stops whoever or whatever is happening. The court then steps in, and then the court through their either appointed guardian or conservator takes charge of the situation. You do have to give written notice of the proceedings to both the respondent. This is the individual for whom you are filing for the guardianship, as well as any interested parties. And this could be family members, caregivers, healthcare agents, rep payees, anybody like that who has an interest has to be given notice that you have or are in the process of filing for either the guardianship or the conservatorship. The court then will hold a hearing, which is basically to determine the capacity of the individual and whether or not there is a need for a guardianship or conservatorship. Witnesses are frequently called to testify why this individual either needs or does not need a guardian or a conservator. The guardian or the court then will decide whether or not the guardian or conservator is needed, and then they will appoint somebody who's willing to serve in that position. In previous years, if there was no one involved or available to serve as a guardian or a conservator, we frequently would have that responsibility given to the county departments of human services. At this point in time, the county departments of human services in most counties in Colorado do no longer accept that responsibility. And so we do, if we need a guardian or conservator, have to find someone in the community. We do have an Office of Public Guardianship in Colorado. However, it is not available in every county, and it has a maximum number of clients that they can serve. So we're really looking as we go through a guardianship for incapacity. An incapacitated person, as we're going through the court process, is not only unable to give informed consent, but then an incapacitated person is also not able to effectively evaluate information and communicate their decision in a way that other people can understand what it is that they are trying to convey. The impairment could be total or partial, and it could be such that the individual is unable to manage either their financial resources or they are not able to take care of their own physical health, welfare, and safety. When filing a guardianship, this is usually the process. A guardianship almost always anymore requires a physician's letter. The physician or a neurologist, a neuropsychiatrist, someone needs to have done some type of an evaluation that indicates that the individual is unable to either mentally or physically care for themselves. You then file the application with the probate court. And so again, making sure that you get in the right court. If you hire an attorney, obviously they will know where they're supposed to go. If you are doing it pro se or doing it yourself, then you will want to make sure that you are in the right court. And the reason being, because you will hear sometimes that the court will look at a filing and they will decide whether or not you are, whether you have filed in the right court, asking for the right determination, and whether that court has authority to rule on what it is that you are asking them to do. You have to give notice to the interested parties. You also have to show that a medical and a financial power of attorney are not an option. And a few years ago, I was in a situation where I had a lady's both medical and financial power of attorney. but she was not willing to go to assisted living, and she had become a danger to herself in the sense that she was no longer eating properly. She was seen urinating in public a few times because she needed to go and didn't realize that she couldn't just sit down and squat in somebody's yard. She was not able to manage her money anymore, but she also refused to go to an assisted living. So we were required to get a guardianship, and then she was court ordered to go to the assisted living. The court then will also appoint this guardian ad litem, which is basically a person who represents the individual. This is the court procedure. And if you go to any of the court websites, they basically will walk you through this process. Any process, if you will, has always in the area of transparency, there is always notice given, and there is public testimony, public hearing. All of that needs to occur. So the court procedure is that your first step is that you file a petition with the court for the guardianship or conservatorship. The court then looks at that petition and sets a date for a hearing. They issue a citation then that the individual for whom the guardianship or conservatorship is being requested must appear in court. That notice then has to be served, if you will, to the individual. And again, they have to be due process. So it has to, you can't just say, I told Mary that we have to go to court. It has to be served by a non-interested party, and you have to show proof that it was in fact served. So even if the person is not able to give informed consent, you still have to show that the note or the citation was in fact given to the individual. And then the individual, basically, there is a hearing in which both sides present their case. And then the judge issues an order appointing someone to be the guardian. There's also letters of the guardianship that are given to the ward on the actions and letting the ward know what happens. Again, oftentimes, in my experience, the ward is not necessarily understanding what is going on, which again is why we are acting with the support of the court. Notice of entry then basically means that the individual, that the court order is entered into the records. Then there is the ward has to be served again, and we have to show that there is proof of service, that a guardian or a conservator has been approved. The duties then of the guardian, I laid those out a little bit ago, looking more at it from the responsibility of what are the needs of the individual. So as a guardian, you are basically given the authority to decide on matters relating to the physical health and well-being of the individual. So you decide where the person is going to live. You decide who is going to care for them, what kind of clothing, furniture, vehicles. You're going to consent or withhold medical treatment, and you're going to provide for the care, comfort, and overall well-being of the individual. Most of the time, the court withholds any type of authority of the guardian to admit anyone for mental health treatment. So, for example, the gentleman that I am currently a guardian for, were he to need to go to an acute care hospital, I have the authority as his guardian to admit him to the hospital. However, if he were to need mental health, a mental health hospital, I would have to go to the court and get the court then to either admit him to the hospital if he wouldn't do it voluntarily, or the court would take over that responsibility and they would do the admission. This has been done primarily for, again, the purpose of protecting the ward's right and making sure that people are not, if you will, admitted to mental health hospitals or other institutions without the need and due diligence being done. So, as a guardian, the court is going to hold you to a standard of what an ordinary person would do to a relative with relative to their own care. So if I was going to make dinner every day at 6 o'clock for myself, then I would want within a similar time frame to make sure that that my ward also received dinner somewhere around 5 or 6 o'clock in the evening. So this standard, if you will, is that if I would take myself to the doctor for, say, a cold or the flu, then I would be expected to take my ward there as well. If I believed that this was a cold that was just passing through and there didn't appear to be any significant fevers or other discomfort, I might just treat that cold with Tylenol and other over-the-counter medications. A guardian is expected to visit the individual either in person or at least to check in with them regularly and to advocate for that individual's best interests. The guardian is also functions as an advocate for the ward to make sure that they get the health care and treatment that they need. One of the things, again, that we always want to be aware of is that sometimes in the community, in the medical profession, in certain types of care centers, we observe a discrepancy in the kinds of services that are delivered to people who can pay for care, to people who have Medicare versus people who may be indigent or who may not be able to advocate for themselves. So we want to make sure that as the guardian, we are a strong advocate for that individual. You do have to, as I said, make an annual report to the court. If the individual is in any type of a care facility or in home care, you need to, or you should participate in any type of staffing meetings, care conferences. You need to, again, as I said, be the advocate. So you're asking about if there's a certain type of care that's being proposed or a certain type of surgery, that you understand what the risks and benefits are, and that you do your diligence in talking to healthcare providers and other community professionals to make sure that you understand if you are making this decision, is this decision that either you would make for yourself, or is this the decision that you know that the ward or the individual would like to have made on their behalf? So oftentimes when I'm serving either as a power of attorney or as a guardian for people, I try to put my own values away and say, what is it that the individual would want? So I often give the example of my father, who very much believed, as a good Catholic, that we should use all available healthcare and technology known to man to save life. And so, as he was at his end of life, it made sense for us to use all of those healthcare procedures that were available. As opposed to myself, I might very well select hospice care and enjoy the quality of life, as opposed to being hooked up to a number of different machines. Another thing that you always want to do when you're acting as a guardian is that you want to make sure that you are looking at the least restrictive setting, especially in terms of housing. So if the individual is able to live in the community, in their own apartment, or in a group setting, that is usually our first choice. If they need some supervision and oversight, obviously assisted living can become, or some type of group living, residential care may make sense. And our least or last resort is that if the individual is unable to be safe in either of the previous two settings, that we would place them in a skilled nursing facility. Honoring people's preferences is extremely important, because that is part of your responsibility as well, is to bring that individual as much quality of life as you can. You also are required to keep them as independent as possible. And with this standard, basically, you are charged with acting, if you will, to the expressed wishes of the ward. And sometimes you can act against the ward's decisions, but you have to have a compelling reason for doing that. And usually that has to be authorized by the court, and that decision has to meet basically the requirements of health, safety, and protection from abuse, exploitation, or neglect. There should be an assessment of the ward's understanding, the level of risk, and what effort that you have gone to include their wishes in your decision making. So again, going back to the lady that I talked about a few minutes ago, where she was not eating and she was, defecating in people's yards and was just not safe. Her wishes, which were to continue to live in her own apartment, we were not able to follow those. But the court was very specific and said that she needed to be in assisted living. And then the court also gave me the authority or the power to move her from assisted living into a higher level of care, should that be required. Now, courts also, and the law, the statutes, do have some protections for the guardian. So as a guardian, you are not responsible to financially support or provide direct care for the ward. What that means is that you do not have to use your money to pay the rent for your ward. You do not have to bring the ward into your home and provide for their care as their health care deteriorates. You have the authority to use community services and community supports to have those needs met. So, for example, even though I might be the guardian or the conservator, I may not want, or I may not have the skills to manage that person's estate. So say that I was appointed guardian and there was some real estate involved, there was a trust, there were some investments, some securities, some stocks and bonds. I might and have the authority to hire, real estate professionals to manage the real estate portfolio. I would have the ability to hire financial personnel to manage the stock portfolio. And I could also hire a trustee to manage the trust. Similarly, I have the authority as the guardian to get care in an assisted living, a home care setting, a nursing home. The guardian is also immune for personal civil liability if he or she acts in good faith with the ward's best interest in mind and with diligence and care. So again, I cannot be prosecuted if I make a decision that the individual should in fact be moved from, say, assisted living to a nursing home because they need a higher level of care. And if I have done my due diligence about selecting what I consider to be the best nursing home for that individual to meet their need, and that individual ends up being exploited or abused in that nursing home, I cannot be held liable civilly for that type of crime. Guardians do have limitations. And so an incapacitated person does have the right to refuse treatment for mental illness, developmental disabilities, or substance abuse. So even though I, as the guardian, might feel that we should seek certain types of care, say I believe that we should go to a geriatric psychiatric facility for medication management for somebody who has a diagnosed mental illness. If the person refuses to go, I, as the guardian, cannot force them to do that. The right to refuse is only valid if a discussion is held with the individual through the court system. So again, if I believe that we should be seeking mental health treatment and the court has withheld that right, then I have to go through the court and explain to the court why I believe that that is important. Medication administration can only be forced, again, if there's a good faith effort to convince the individual to take the medications. If that has failed and the incapacitated person refuses, then again, you can go back into court and they can be mandated to take medications. But again, that is the responsibility of the court to mandate medications if the individual does not voluntarily participate. Treatments such as ECT, psychosurgery, experimental research also are going to require the consent of the individual and the guardian, and most likely the courts as well. So the guardian is also, there are some restrictions about secluding or restraining the individual. So if there are restraints used, those have to be FDA approved, and they can only be used in emergency and when it is proven that less intensive treatments have failed. So we can no longer take an individual who is, say, a flight risk in a mental health ward and tie them to the bed in a 5-point tie. That is totally illegal at this stage of the game. We focus much more on behavioral intervention, monitoring, and support, coming up with some type of a plan, either to have those behavioral interventions continued or phased out if we've had to do any type of restraints. Guardian does have the ability to make decisions regarding life-sustaining or ending therapies. So, as a guardian, you do have the authority to either decline or withdraw life support. This could include you need to really look to see if the individual, if there is no clear direction regarding such treatment. So, for example, if the individual gave informed consent at some point in time on a living will that they wanted, again, all type of life-sustaining measures used, such as feeding tubes, ventilators, that kind of support, then as the guardian, you're required to follow that. But if there's no clear direction, then you can use, again, your best judgment based on what you know about the individual in terms of either declining or withdrawing treatment. The guardian has the authority to decline artificial anhydration only if the physician and two independent physicians determine that there is reasonable medical certainty that the person is a vegetable, and the guardian determines, again, in good faith, that treatment withdrawal is in the person's best interest. So again, this follows relatively closely on some of the advanced directives, which is one of the reasons why it's really important for you as an individual and everyone you know to provide advanced directives, because that then helps me and other loved ones know exactly what you want. The guardian has to basically presume what is in the best interest if we continue life, and then what is in the best interest if we withdraw any type of life supports, and what is it that we believe are the wishes of the individual. If there is a chance that the person may recover or that the treatment would be effective, and there's no clear direction, then the guardian can withdraw life-sustaining treatment. If there is clear direction that the individual would like life-sustaining treatment, then we need to operate from that perspective if there is a chance for recovery or that the treatment will work. Guardians are required to give notice to individuals, interested parties, and to allow for response and deliberation, so that if anyone wants to object and or petition the court to review the decision, there is time to do that. Again, that's really important when we are looking at individuals who may be in a chronic persistent vegetative state. Other limitations in terms of treatment for terminal illness. If we are treating a terminal illness and the treatments are painful or intrusive and they prolong dying rather than restoring health and function, then again, the guardian can decline those services. The guardian cannot, however, base this decision on a determination that the life of the disabled person is lower or of less value than that of others. So I cannot say I'm not going to provide care because this person has dementia. That is not an acceptable decision or decision base for making a decision to withdraw treatment. Rather, I have to make the decision based on what do I believe the individual will want, or if we continue this treatment, are we really just prolonging the dying process? If there is any concern, if there is different opinions expressed by family members, If there are religious implications that come into play, you may want to refer those decisions to the courts. As I've said several times, the ward's preferences are really very important here. So the guardian is really required to determine what the individual's preferences are and to determine whether or not, if we follow what it is that the individual is requesting, whether that is in their best interest. And we need to make the determination as to whether or not it will compromise their health and safety. As I said earlier, we always want to look for the least restrictive environment in which we believe that the individual can maintain the highest level of functioning. This is true whether we are in a long-term appointment or whether we are in a short-term appointment, such as a rehab facility following a surgery or a hospitalization. The ward does have a right to sexual expression and activity. So if they have consent to give sexual activity, it's protected so long as it appears that it is knowing and voluntary. And sexual consent is one of the problems that we frequently see in long-term care. If the individual lacks the capacity to consent, then sexual activity basically becomes sexual abuse. And if there is a predator who knows of that incapacity, then we are actually looking at criminal sexual assault. So the challenge that we have often in long-term care is what type of informed consent can we actually give to sexual activity? I maintain that if I can't give informed consent to my finances or where I want to live, then I probably cannot give informed consent to sexual activity. Now, does that mean I'm not able to enjoy closeness, that I am not able to enjoy affection, that I might choose not to be close to someone or to hold hands, those kinds of things, as long as both parties appear to be enjoying that intimacy and that relationship, then it's okay for that sexual activity to continue. If either party seems to be in pain or stressed by the relationship, then in long-term care, we need to basically intervene so as to avoid any type of sexual abuse. So this is just kind of putting it all together, optimizing care under the guardianship. And so you can kind of start at any place on the circle and just go around. Our goal, as I said often, is to optimize the individual's ability to be independent and for them to identify what their incapacity is. We want to always screen for elder abuse and financial exploitation. We want to be a strong advocate for helping them to get the care and services that they need. We need to understand the reason why a guardianship is being put into place. We need to communicate that not only with the courts, but also with any other individuals who are involved in the care and service delivery for the individual. We want to then engage the individual in as much decision-making capability as they can manage. So this might be giving them very limited choices, or sometimes I find with individuals who are chronically mentally ill that if they are stable on their medications, they can actually be very involved in large parts of their daily lives. We need to evaluate their situation on an ongoing basis to see whether or not there has been any changes, either clinically or physically, and whether or not we want to continue that. Guardianship can be terminated. It terminates when the ward dies. So again, it's like a power of attorney. When the individual dies, then the guardianship or the power of attorney dies at that moment. A guardian can set up funeral plans if the ward has funds. Many powers of attorney will function in that role after after their individual passes away. But some funeral homes now are starting to request that we have actually a funeral, either a pre-need funeral plan that can be put into place, and we have the authority to sign on that, and that comes basically via a simple will. It may be more complicated, but one of the very first things in a will that someone should put is the ability for the trustee or the executor or the representative to bury the remains. An emergency guardianship, this is court appointed on an emergency basis if there's substantial harm to the person's health, safety, and welfare, and that further harm will occur if we do not act in an emergency basis. You do need to explain that, and there is a separate form that needs to be solved or filed. Adult Protective Services, they are not in the business of doing guardianships, as I said, these days. These are the people that you call for mandatory reporting of abuse, neglect, or exploitation. However, you normally would call the police. They would investigate, and then if there's a need for a referral to Adult Protective Services, they would make that. Adult Protective Services is charged with investigating elder abuse, and the counties do not accept guardianships, and the Colorado Office of Public Guardianship is very limited in what they can do. So the advanced care planning resources that we have here at the Colorado Gerontological Society is that we can help you with individual counseling and support. We can make referrals for to elder law attorneys and other experts, such as pre-need funeral counselors and folks like that. You can review our advanced care planning toolkit, which is available at our website. We also have a playlist at our YouTube channel, and we do a fair amount of educational programming associated with advanced care planning. This is a little bit about advanced care planning services. We can provide you with the pre-printed forms as well. Our services are available in English and Spanish, should you need that support. And then these last two slides specifically look at services that we provide through the Colorado Gerontological Society. And some of them are available in the Metro Denver area. Some are available throughout the state. If you have questions, you're welcome to give us a call, and we're happy to walk you through those. And so that is the end of this presentation. There is at least one question in the chat, and it says, must a fiduciary be an attorney? And the answer is no. A fiduciary does not have to be an attorney. It can be an individual in the community, such as an accountant, or it could just be a lay person who is willing to take on those skills and or who has those skills and is willing to be responsible for managing funds or an estate or a trust or whatever.